You know, every time you sign a contract, you're agreeing to way more than just what's written down on the page. Today, we're going to pull back the curtain on the hidden rules, the invisible terms that are legally baked into your agreement, whether you know about them or not. Because let's be honest, what you don't see can be just as important, if not more powerful, than what you do. These are the unwritten rules that either make the whole deal work or become your legal safety net when everything goes sideways. And there's a name for them: implied terms. They aren't spelled out in black and white, but the law says, yep, that's part of the deal anyway. And as we're going to see, they can pop up because of the situation, because of fairness, or because the law itself puts them there. So here's our game plan. We'll kick things off with terms that come from the specific facts of a deal. Then we'll look at how the law steps in to make things fair. We'll also cover how modern laws give you some serious protection as a consumer. And finally, we'll tie it all together so you can see why this stuff really matters in your everyday life. All right, let's dive into our first category: terms implied in fact. This is all about figuring out what both parties must have meant, even if nobody bothered to actually say it out loud. These are the kinds of terms that are so fundamental, the contract would be completely pointless without them. So how do courts read between the lines? Well, they don't just guess. They've got two main tools they use to decide if an unwritten rule should officially be part of the contract. On one side, you've got the business efficacy test. This one's pretty straightforward. It just asks, is this term absolutely necessary to make the contract work in a practical business sense? It's all about workability. Then on the other side, you've got the officious bystander test. This one asks a different question. Is this term so ridiculously obvious that it just goes without saying? This one is pure common sense. To really get what the business efficacy test is all about, we've got to travel back to 1889 to a classic case that actually created it. It's a great story, and it perfectly shows this idea in action. The case is called the Moorcock. So picture this: a ship owner pays to use a jetty to unload his stuff. Simple enough, right? But when the tide goes out, the ship scrapes the bottom of the riverbed and gets damaged. The contract didn't say a single word about who was responsible for making sure the riverbed was safe. The court looked at this and basically said, come on, for this deal to make any business sense at all, we have to assume the jetty owner was promising the mooring was reasonably safe. Without that assumed promise, the whole contract was useless. It had no business efficacy. And that brings us to our second tool, the officious bystander test. The name comes from this brilliant quote. Just imagine some nosy, meddling person, an officious bystander, is watching you make a deal and chimes in with, shouldn't you add this rule? If both parties would just roll their eyes and snap back, of course, then the law says that term is already in there. Yeah, an easier way to think about it, it's the duh test. If a term is so obvious that everyone would just assume it's part of the deal, then the courts can imply it simply because it would be ridiculous not to. Now, let's switch gears. Some implied terms have nothing to do with what the parties intended. These are terms implied in law. They get inserted into certain types of contracts really as a matter of public policy, and usually it's to protect the person with less power in the deal. A perfect and pretty powerful example of this is the case of Liverpool City Council versus Irwin. It really shows a court stepping in to make things right when a contract totally failed to. So here's the scene. You've got tenants in a tower block, and the place is falling apart. The elevators are broken, the stairwells are pitch black. It's bad. Now, their tenancy agreement spelled out all of their responsibilities, but it was completely silent about the landlord's duty to maintain the common areas. The court ruled that for this type of relationship, a tenancy, the law itself implies a term that the landlord has to keep the common areas in reasonable shape. It wasn't about what the council intended. It was about ensuring a basic, decent standard of living. And that leads us to the heavy hitter, the most powerful category of all: implied terms created by statute. These are rules that are literally written into law and automatically dropped into certain contracts. And here's the most important part: you can't sign them away. A fantastic example of this is the Consumer Rights Act of 2015. This law is an absolute game changer. It was designed to level the playing field for all of us, automatically writing some fundamental protections into any contract you make when you buy stuff. For example, Section 9 of the Act says that any goods you buy must be of satisfactory quality. And that's not some vague idea. It means the product has to be fit for purpose, look decent, be free from small defects, be safe, and last for a reasonable amount of time. The law basically says these standards are a non-negotiable part of the deal. What this really creates is a legal safety net for you as a consumer.
It doesn't matter what the fine print says. It doesn't even matter if a company tries to get you to waive these rights. The law steps in and says, nope, these protections are locked in. It's incredibly powerful.
Okay, so let's wrap this all up. Why does any of this matter? It matters because implied terms are the invisible blueprint for pretty much every single agreement we make.
They're the legal glue holding it all together. They ensure deals are actually practical. That's our business efficacy test. They inject a dose of common sense. That's the duh test. And most importantly, they act as a shield, stepping in to ensure fairness and protect people when there's a power imbalance, like between a landlord and a tenant, or a big business and a single customer.
So the next time you sign something, buy a new gadget, or even just click I agree online, just take a second to think beyond the words on the screen. Because now you know to ask, what are the unwritten rules shaping this deal, and how are they working to protect me?